So. Okay, recording is now in progress. Everybody, welcome to our meeting, sort of, in the new room and in online. So, welcome to Chris, and take it away, John and Kevin.
So Kevin, do you want me to proceed?
You do it all. I can't, you're the chair.
Okay. What an honor.
Mm.
Well, the stormwater meeting will come to order on 7 o'clock
Mm-hmm.
for the May 28th meeting. So we will, our group is growing.
Mm-hmm. Mm-hmm.
So I guess we better take a roll call before we lose anybody.
Yeah.
We have Sue.
Here.
Are you here?
I'm here.
Deb here?
I'm here.
Okay. Yeah, Josh,
I'm here.
John here, Kevin,
Here.
Trip,
Here.
Tom. Here. Okay, I heard that. So I think that's everybody. Janine,
Here.
okay. And I guess
And you're
we're
here.
set, and I'm here, yeah.
You're here. Okay.
Okay, we have much more than a quorum. We have quality, we may not have quantity. Okay. Okay, we got two sets of minutes to discuss. Thank you, Kim, for getting all that out.
You're welcome.
Start with the April 23rd meeting. Any comments on that?
No.
Who our chief reviewer says she's good.
Both minutes look great.
I love it when Sue says it's good.
It does
Okay,
feel good, doesn't it?
Okay,
It looks great.
It's almost like when your teacher gives you like a gold star in
Mhm.
class.
Mhm.
I am always clapping, thinking I'm so proud.
Yep.
okay, do we have a motion to approve April 23rd minutes?
I'll move that.
Josh moves.
Josh has moved it. Who seconds?
I second.
2 seconds.
Okay,
Voting. You
all
want
in
to go through the
favor?
list?
Can we just go?
To do a roll call.
Okay. Boy, really working it here.
Do you want me to do it?
Sure, you're so good at it.
Okay. Oops,
You gotta
and Joe Prondek has joined us, so give me just a moment to promote him really quickly.
Geez, I should have stayed home. It was my remote day. I
Hmm.
was like, I should be.
Okay. Alrighty, so approving of April 23rd meeting minutes, roll call to accept. Sue,
Aye.
Deb,
Aye.
John,
Yes,
Josh,
Yes.
Kevin,
Yes.
Trip,
Yes.
Janine,
Yes.
and Joe, if you can hear us now that you've just joined.
yes.
Okay, and Tom, still not in the room. Okay, no worries. We'll get him on the next one. Okay, take it away, John. Next one to approve.
Okay, then we got the our May 13 minutes. Do we have comments?
No comment here.
No comment,
Wow.
Good.
yes,
This is rare. This is rare.
Right.
I did read them. I like the part about the proposed dates may not be feasible, so we'll get around to that, we'll get around to that later. But
Okay.
You guessed
We
right.
will, who's gonna motion to accept?
So moved. I'll second.
Joe motions, and who seconded? Deb seconded? Yay, okay, Deb seconded. And roll call vote would be Sue,
Aye.
Deb,
Aye.
John,
Yes,
Josh,
I wasn't here. I'll abstain.
Kevin,
Aye.
Trip,
Aye.
Janine,
Yes.
Joe,
Yep.
Is everyone here?
Tom, Still not in the room. Okay, moving on. Yay, all minutes accepted. Okay, next on the list.
I think we are gonna discuss the town council's comments. Does everybody know,
Should
Chris?
we wait for Tom for a minute and do
Yeah.
Do
something
you want,
else?
do we want to skip that one and go to the schedule of the minutes and other things, or do we not want to do that till we find out what the illustrious
it-
town council has advised?
I think it would be wise to wait for Tom, because he and Chris have talked. If we can at least sort of pick up, where they have left off and not.
And that way you can hang
Replow
out with us
ground.
longer.
You get to
My
see,
pleasure.
us in
He has
action.
nothing better to do on a Wednesday night than hang out with
No,
us.
nobody does. Nobody does.
Can
And
I,
then
This is
can
keep-
I,
getting me out of a Watertown zoning board of appeals meeting. So
Oh,
tell me.
nice,
can
nice.
can I suggest that we have Chris do a quick little hiya, how are ya introduction to those of us who have not actually met him and who he has not met us perhaps on this
Sure.
committee?
Sure. So hello, everybody. I think I know most people in the room. I'm at the chair and
I'm Sue.
I'm Chris. And to those on the Zoom, hello. So yeah, so I'm Chris Heap. I'm town council. And I'm, happy to jump in and join the discussion. You guys have been at this for a long time now. I'm just happy to sort of step in and sort of offer some comments and questions and suggestions as we try to get this across the finish line.
Thank you.
Chris,
Any
out of
reason-
general curiosity, how long have you been town council for Needham?
I've been town council in Needham. So I've been serving as town council since 2020, and formally appointed, I want to say, about 2 or 3 years ago.
Wow, okay. Great. Thank you.
Sure.
I just had a couple general comments, Kim. And I know Tom has probably plowed all this ground, but I just wanted to give you a little feel for how we kind of got to where we did. And I think as the outsider, one of the outsiders in the group that's not part of the town government, it was an interesting process, and I liked how we went about it, that we really started with the existing ordinance and thought about how can we build on it and improve it, rather than throwing it in the trash can and starting anew. And we really tried to assess what are the weaknesses and deficiencies, and we spent a couple meetings really, I thought, talking that through and documenting, the areas that needed to be shored up, and I think came up with a half dozen major points. And then we secondly really felt that we could benefit from looking what others have done and not necessarily reinventing the wheel. And we plowed through a lot of other ordinances from other communities. And I think, Kim, our two primaries were, Natick became sort of one very good example. I think Tom had suggested that we look at Weston, so we kind of looked at that a little bit. Interesting that you're working in Watertown, so
Mm.
I don't know whether you've gotten into their
I
stormwater
actually, no,
side of
I
things,
actually
but
live there. So
that's a whole new dimension that I've learned about through some other activities I'm doing. So I think we've been, and also there were some standards, that the Beta, the stormwater consultant, had suggested. So we really, Kim led us through a fairly thorough section by section and comparing what everybody did. So we ended up, where we ended up. So it's kind of nice to have a fresh set of eyes looking at it. at
Well,
this
I was gonna say that I think that's what I hope I'll bring tonight in terms of my comments and questions is a fresh set of eyes. I know that the group has been working on the draft for some time. And, some of my questions are just sort of directed at, I think, making sure that all the term in what is a long and complicated bylaw, all of the terminology, phrasing, sort of is consistent with internally within the bylaw.
So
Perfect.
Kim, were you suggesting that we maybe? I think it would be beneficial to have Tom here as we launch into this discussion. Can
Mhm.
we talk about the schedule Kevin's on, so he can maybe enlighten us a little bit on constraints from the select board end, but we really, kind of, have you thought through it all from your vantage point, what a schedule might look like for getting to the end line?
For me?
Yeah,
Oh, for me, well, for me, I would love it if we'd work up to the nth hour. However, I know we need to do a couple things in between that. So here's the tasks we need to get done. We need to finish up with the draft. We need to have a presentation, a high level, broad brushstroke presentation to the select board, just to let them know how things are going, what's happening. We also wanted to have a public listening session to let the public know ahead of this showing up on a town warrant, that it's coming for a vote, so they can express any questions or concerns. I need to edit and update the draft with any comments that you all have. We need to gather together the presentation that we would use for either one of those meetings. And we also need to at least start, consider, or have a rough idea of the regulations. In my preference, I'd love to see the regulations done prior to, at the same time as the bylaw being voted. If it does pass town meeting, I'd love to go to the select board whenever their meeting closest to that happening is, and ask them to pass the regulations as soon as the bylaw gets passed. However, if that is not feasible, given our time constraints or our availability, the regulations could be pushed down the line a little bit, but I just don't want to happen what happened last time, where it said regulations are coming and it's now 5 years later and we still don't have it.
Yeah.
And sorry, I think that's a great idea. I think there's always some danger when you are doing substantive regulation of anything in the form of a regulation. You need to adopt a bylaw to make it happen, that, deferring until later, the actual regulations could leave open the question, what are we actually doing? It is,
Exactly.
I think, much preferable by a wide margin from my perspective to have the regulations ready to go or close to ready to go, so that you can actually explain to town meeting, we're not deferring the substantive regulation to some later date. We know what we want to do. And this is what it's gonna look like. I think that's the better approach.
Yeah, I mean, I'd like to see us have all of our meetings, and once the meeting, the public comment meeting is done and we have this draft finalized, we hop right into the regulations, because that is we need 45 days before town meeting to submit our stuff to for town meeting. So that gives us, I mean, ostensibly, we would have essentially the month of August and September to get through the regulations, which I feel like that could be done, because we have a good, if we go with what is in the stormwater bylaw recommendations, based on feedback and anything else, it would be, I think we have a fairly good outline in place to start to putting regulations together. And we have the original draft regulations document that was started back in, I think, 2018 or something like that. So we can refer to that, but I don't feel like regulations will be as daunting of a task, because we have the framework of the bylaw already decided.
Did
Well,
we
you just
figure out
jinxed
if
it, you
our
know.
group is the same group that's gonna be doing the regulations?
I think it has to, it should be.
Yeah, I know. I just vaguely remember some discussion that.
Yeah, it's
Okay.
not part of the working group's quote unquote mandate from the select board was not to create regulations, but I think at the first couple of meetings, we kind of really all felt, or you guys all really felt, because I'm not really here, you guys all really felt that it was appropriate for us to have accompanying regulations with this bylaw, specifically because we were making such I wouldn't say sweeping changes, but we were making substantial changes to.
Oh, is it something we need to ask the select board to give us a charge to get done? You
That
know,
I do not know. I will leave that to the select board. Gurus.
Okay.
You think our charge is general enough that
I'd have to review it again. I mean, we have to extend the term again, I think, anyway, so
yeah,
Yeah,
at the same time, we can review that.
Kim, I'm not as optimistic as you are, because I know there were a few things as we went through the bylaw that we said, we'll deal with that in the regulations.
Yep.
So the regulations already are pretty heavy duty. I've been through them a couple of times in terms of the level of detail on a number of aspects that are in there. So not that we can't plow through that, but you know, it will take some time if that's the sense that we need to have it, you know, completely developed concurrently with the approval of the bylaw, which I agree is the ideal course, but it's gonna take some work.
Yeah, I mean, the faster we get done with the bylaw itself, with all edits and comments, may do the presentation and then do the public participation thing, the sooner we can start working on the regulations. So whenever you think you could make that happen, that's great. I just know that it is a little constraint wise as far as meeting availability, especially during the summers. And we wanted to get meetings happening, or the public participation ideally was gonna happen like as close to the end of the school year as possible, so that people took off for the summer, they were still available. However, because we are anticipating it being a hybrid opportunity, I don't feel like that is that big of a deterrent to people attending if they are really interested or have a really significant opinion about something they need to talk about, they can attend online. So as long as they're not, you know, excuse me, taking the summer off to go to the Amazon or something where there's no internet access, I'm pretty confident that they could still have they could attend.
Well, let
Kevin,
me
did
ask,
you want something?
yeah. We have, Chris, our pinch point is actually, when does the warrant close for a fall town meeting?
I'd have to check with Kate, but I would have to assume that that's early October.
She
Yeah, I
thinks
think it's the second week in October as the meeting, the town meeting. So we have to get all our stuff in 45 days ahead of that.
before
So it'd
town.
be mid-August.
Late September.
Wait. So wait, what's mid-August?
I guess I'd want to check with Kate, Kevin,
All right.
but
Because the question is, can we have we can do a hearing in the summer, but some people may think that that's not valid as something, you know, during the regular year. So I think we're kind of like, we can hustle and get this done over the summer, but are we going to be ready for town meeting? And then, you know, springtime annual town meeting is a long way off. So like we have a real crunch.
I'd prefer not to push it to May next year. I want to aim for this.
we gotta somehow get there. I think we're all
Okay.
agree with that, and I think
Because you probably want to catch to the construction season of like people starting up projects and knowing what they're getting into once, if the bylaw changes, if that's gonna change anyone, if they're like planning to build a house next spring, you know. You'd want to know that going into it, what's gonna affect them when they pull the permit rather than, you know. Although I
Bring
don't
it
know,
on
would it
them.
go in place, would it take like an additional, like, it wouldn't go in place of the following July technically?
I don't think we discussed when it would take effect, actually.
So maybe what I'm saying is, all right,
You
forget what I
make-
said.
bylaw approval in October, late October,
Yeah.
that would get Attorney General approval early part of next year, and it could certainly be ready. It could certainly be effective, I would think, by the spring construction season. And would apply to any building permits that were pulled after the effective date.
Did I see somewhere that Neptys is on some revisions? Is Neptys being updated somehow?
Nifty's has excuse me, has a new draft MS4 permit coming
Yeah,
out.
we're going through some of that now.
Yeah, their MS4 permit revision, which is, we've been on administrative continuance for the past 3 years, almost 3 years. That one is being updated as well. Their regulations are being updated. They had their public meeting last 2 weeks ago, 3 weeks ago now.
Is
weeks
that gonna be affecting is that gonna be affecting our draft bylaw?
No, actually, we have incorporated a lot of the stuff that would be in that new NIPD's permit, or the parameters around it in this draft. That was part of the discussions that we were having all the way through, was all the changes that potentially would be coming along, and how our
Okay.
bylaw needs to be able to be malleable enough to be able to kind of roll with the punches. So we're not doing this on an annual basis or every time
Good,
EPA
good.
changes their regulations.
Good.
Just one other point to cover all the bases here. Ask Chris if we have the presentation to the select board and the listening session before the regulations are complete, is there any risk there, or are those really considered sort of details that don't matter in those two functions?
I don't know how much it matters, I think is gonna depend on the audience and the questions that people may have. But I think with a bylaw of this type, it's one of the first things that I think, one of the first questions I ask is, what are the performance standards that we're going to be held to? And if those performance standards don't appear in the bylaw itself, and they're going to appear instead in the regulations, I think people would be fairly curious about what standards they're going to be held to if they come under the jurisdiction of the bylaw. So that's a long way.
I agree.
I think it matters. I think it would matter to someone attending a public hearing on a bylaw change for a bylaw like this. Is that?
Okay.
And then,
Yeah, that's not what I wanted to hear, but
So,
that's, I don't know, Josh, what do you think?
well, just for context, the way we've been discussing that the role of the regulations is how the bylaws are implemented. So the regulations set all the standards. And then the bylaw sets all the standards, and the regulations, describe,
How you get those standards done.
yeah, if there's going to be, some sort of template or measurement standard, that's how it's implemented.
in that framework, then I'm not worried.
Yeah.
Nearly as much about the regulations not being done or close to done. I guess I was assuming.
Well, we want the bylaw to be loose enough, right?
If
So
we're-
that it's,
If we're talking application, contents of an application, timeline for permit review. Plan size that you gotta submit for review, those types of things can appear in a regulation, and I don't think that anybody could be bothered by that. However, I thought I understood from conversation with Tom that there had been some interest in putting sort of actual substantive criteria for what you need to do to satisfy the bylaw. In terms of, allowing for X amount of infiltration or Y amount of infiltration in various situations. If those things are appearing in regulations, I think people could probably want to know what those standards are when the bylaw is being adopted. If that makes sense.
That makes sense. If that were the case, I would agree with you. I think in our discussions, we were talking about 1.5 inches of water per square foot of impermeable surface. Like, that is in the bylaw. That's like the clear standard.
Right, what we discussed was the regulations would give you methods of how to either reach that or how to satisfy the bylaw statement or the bylaw section in other methods. If the way that you if the standard way to approach that and accomplish that task is not applicable to your property for some particular reason, these are your alternative measures you could take, or the alternative things you could do. That was sort of what the regulations were for. Joe has a question.
Yeah, well, I have two actually. What comment, I think, that at the public listening session, there's also going to be a factor of folks, and maybe more so than people asking, what will be the parameters of the bylaw? I think people are going to be asking, what's this bylaw going to do for us in a flooding situation? I think we have to be prepared for that type of question. And then my other question is, does anybody know where Tom is? Is he here? Because he was all gung ho at about 3 o'clock.
Yeah, he is. He had
Yes,
he
he is.
was double booked, so he's just
Oh, okay. I didn't know
he's
that.
doing something else at the same time.
Okay.
And and I'm comfortable launching into my comments anytime, or questions.
Yeah.
Anytime you want to go with or without Tom, so I'm happy to wait.
No, I mean, but I think this is a key point and just
Why don't
getting
I-
everybody to
I'll
weigh
go
in on.
Upstairs, see.
I mean,
Oh,
it
he
seems
thinks
to
he'll
me
be
that
Imminent.
kind of
Yeah,
echoing
he
what
shouldn't
Josh said, that the thresholds and sort of those key parameters are gonna be in the bylaw. And it's more, things like if you've got poor soils, what is the methodology for how you build justification for, getting some kind of waiver, so. I think we've just got to be sort of acutely aware as we're sort of doing the final crafting to be sure that we can navigate around this,
I think it's
pitfall.
probably, maybe we want to get to the end and come up with a list of what would go in the regulations.
And you may
decide.
be a good source of saying you really need to pin that down
I think-
more to avoid a future,
I'm happy.
problem.
Chris,
Yes,
what was Tom referring to when he said certain criteria? Would be, more certain criteria might be the regulations.
I can't recall specifically, but my impression from our comment, and it did have to do with the amount of infiltration that would be required.
Okay.
But I may have misrepresented.
Did he mention anything about grading?
My memory.
Yeah, I think our discussion essentially was that it was the standard is what it is in the bylaw, and that's what you have to get to. But if
Yep.
you, for some reason, can't attain that for whatever the reason, poor soil, small lot, whatever the case may be, what are your options of how to get to that? How do you answer the bylaw and stay within the rules, but still produce an adequate amount of infiltration?
Yeah.
Yeah, we were talking about like contributing to a fund that then could be used to install like an infiltration systems within the neighborhood. Branching off the existing storm drain system or something like that,
Which we will certainly be talking about.
Which that could get more complex in trying to develop something like that and how that's structured as far as like, what is that dollar amount or like how we kind of figure that and where those projects would be technically
Where you put them off.
done.
Off
Yes.
the applicant's property.
Can I suggest that maybe we try to wrap up our scheduled discussion and then we'll go ahead and get started more methodically with Chris? The
Sounds
question I
delightful to
have,
me.
the question I have is sort of given what we've covered generally. The dates that we were carrying, Kevin, I believe, previously to this point were the June 10th select board presentation and 2 weeks or a week later, the listening session, the 17th.
Yeah.
And I think we
Correct.
all, of us who were here last meeting felt that we weren't gonna be there because that's just around the corner. Is there a set of backup dates that you have in mind for select board meeting?
Yeah, so I'm looking, the next select board meeting after the 10th is, the 24th of June. One day that,
I know, it's okay. We didn't start with Chris.
Yeah, it's just really.
So is the 24th, right
Oh,
now,
we got-
the next select board meeting is the 24th. Is the 24th seem doable to anybody? means basically the month of June we have to finish up this bylaw. Or to at least have our presentation
Okay.
done and everything.
So we give us 2 more weeks to get our job done before the select board
Okay,
presentation. That's kind of what we're talking about on the
Right.
scroll.
So we're looking at
We're all
July.
doing a big gulp.
So
and some-
I guess I would like to also propose that we don't have any further meetings scheduled after tonight. Tonight is our last meeting as far as
Right.
our schedule goes. So getting a
Fix
tentative
that.
schedule for the summertime would probably be appreciated, because then we could see how much actual working time we have.
I guess what I'm not clear on is how long it will take to address the comments. The legal comments.
Well, maybe we should do a legal comment and then figure out.
Now we're talking.
And then
Which
Tim
was
has to
okay.
edit, so please
You guys
don't
need to-
kill me.
No, no.
And that was our original plan for the agenda. So you're right, Josh. Okay, we will put off.
So maybe
the
we'll
schedule
table this
now.
discussion for after we go over the draft
Yeah.
then. Okay, all right. All right, so fair enough. So I'm going to share the draft. I did go ahead and reformat into more of a, let me know when you can see my screen.
Can see your
Yeah.
screen.
Okay,
You
You can see it.
fantastic. Is it large enough for everybody to see?
No,
Oh, that's fine.
Is that the same version that we have in print?
It is, the version that I did save to the SharePoint site, communication site with you. However, it is not the original one that we used to have that had a title
Yeah,
page
I
and
know
table of
that.
contents and stuff. Yeah, but this is that same version, yes.
Okay, well, Tom very nicely, or you, Kim, generated copies that we have here, both the clean copy with everything incorporated and then the comment copy. So I just want to be sure what you're showing up there is one and the
Yep.
same.
Mine has all the comments on the side of the
Okay.
page.
Which is-
So Chris, this sort of attested to your observation that it was not in a regular format. The format we originally had it in was more of a review format that made it
Yeah.
easier for me to put the pieces together. So I just took it and put it in the same vernacular as what we have on our.
Yeah, no, this, I'll double check it, after the meeting tonight, but just at a glance, flipping through it as we're sitting here, it looks great.
Okay.
That looks exactly like what I was talking about, so that.
Okay, all right, great. All right, so do you want me just to go through and start off at the
Actually,
beginning?
if I could just start with like a couple of just sort of preliminary questions. I think I understand the answers, but I just want to sort of get them out there and make sure that everybody's absolutely, that I'm clear, that I guess mostly what I want to try to accomplish tonight is make sure that I understand the direction of the committee so that I can make sure that the bylaw accurately captures what it is we're trying to do. And in most cases, the bylaw does that already perfectly clearly, but I do want to just sort of double check my understanding. So sort of general question number one about the permitting path for applicants under the bylaw. The bylaw provides that if you need, in most cases, if you need a permit from planning board, ZBA, conservation, or a building commissioner, you'll go with them for a permit, and the stormwater review will happen while you're there. I think that's right.
Correct. The stormwater is part of every permit, is part of the permit when it's applicable. So for example, in the building permit because construction is the most common. So on a building permit, if you have a structure going up and it is either 50% or more footprint increase, meaning impervious cover, anything like that, there's a calculation within the permit that states when that triggers a stormwater review.
Yeah. And the stormwater review happens during that permit review, but it's not, as I understand it, its own separate permit. Is that correct?
Correct. We do not have a separate stormwater authority in the town of Needham like other communities do. It is administered by the DPW director is the responsible party for the, for NIPD's. And our original stormwater bylaw was created specifically to address NIPD's regulations and only addressed water quality. The part that we were trying, our mandate, or I shouldn't say our, but the mandate of this group was to address not only quality of water, which is what NIPD's is concerned with, it's the quantity of water in town.
And assuming someone needs a permit from multiple.
Mhm.
Or boards or officials.
Yep.
Will the stormwater review sort of, how do we, what's the hierarchy of review under this bylaw if someone needs to go to different permitting boards?
So if you have a building permit and you also require a conservation approval for that building permit, conservation does do a review within the building permit. However, conservation may issue orders of conditions that go beyond the building permit. So once a building permit ends, our authority over that property through the building department ends. So once
Yeah.
that's closed, it's done. However, if you are on conservation property or property that is, you know, regulated by conservation because of its proximity to the Charles River or a wetland or something of that nature, you would be still subject to orders of conditions for, I would assume, the life of the property or the life of whatever jurisdiction that conservation has. So they don't necessarily issue a separate permit, but they might issue an order of conditions to go with that's within that building permit. Does that make sense?
So we have our own regulations and we have our own stormwater regulations that go in conservation above the building department's regulations.
And
Haven't you had problems though in the past saying, no, the bylaw is this? You know,
Yes.
I may be in wetlands
we-
jurisdiction, but the bylaw says this, so I'm only gonna do what this says. Have you had that issue?
Well, we had, I mean, one specific issue, was that the Conservation Commission, our regulations, we interpreted that they needed to infiltrate stormwater for a property where the house wasn't torn down completely, but went down to the foundation. So conservation felt that that was a tear down and that would trigger that.
Yeah.
Where apparently the building department didn't see it that way, that it wasn't a complete tear down. So, previously in the building department, they were told that they weren't going to need to do that. And then when they came to conservation, we said, no, you do need to do that. And then we got pushed back because their interpretation of the issuing authority, they thought was just the building commissioner. When we're in fact part of the issuing authority, depending on if it's in our jurisdiction.
okay,
So part of the language change in what we're recommending has to do with, instead of going by square footage, because I think just as a general thought process and hearing what the issue might have been, the thought process for, as far as building is concerned, is if they didn't take it down to removing the foundation, it's not changing its footprint, so therefore it doesn't trigger the stormwater bylaw, because we had it listed as a certain square footage. If you're over a certain percentage of square footage, that's when the bylaw triggered. However, the way that we've tried to write it in this instance is to refer to land disturbance as opposed to a specific square footage of impervious cover. So if we don't just include impervious cover, it would capture those things that does have some sort of land disturbance going on.
okay. So I
Does
guess
that make
that's,
sense?
I had a question about land disturbance and all, and
Yeah.
that's.
But you're going into hierarchy, like who's the
So-
permitting authority?
So I can imagine a
Yeah.
scenario, just as a hypothetical, where someone needs to go to. Planning board, conservation commission, and eventually building commissioner, but building commissioner would be their last stop chronologically. They would have the choice of going to the planning board and conservation commission at the same time, or in either order. So in that scenario, do we care? Who does? Should the stormwater review under this bylaw be applied by the first permitting board or official who sees the application? Or should the review under this bylaw be applied by somebody in a hierarchy of conservation goes first, planning?
Right.
So if you go to planning board first and you're eventually going to go to conservation, should conservation do the review? Or should it happen both times with the understanding that the second time it's the same project, and when you guys are asked to look at it, it's not gonna take much time to review it because you've already seen it. Does that question make sense?
Yeah, so I think we've been talking about this a little bit internally, and with Joe. And I think Joe mentioned at the last meeting as well, is like. The planning board and zoning board should just say, must comply with the stormwater. Because it's eventually it's gonna get to building department or goes through.
Doesn't DPW come in a situation like that for overseeing a situation like that?
Yeah, so right now, currently, someone is pulling a building permit. And we have someone in our office who reviews it to make sure it complies with the 1 inch. And Joe's office does the same thing, and so we just reconfirm it. That everything is all set to go, so there's no actual separate permit as part of the building permit, just,
Right.
okay, you're all set to go.
Right, but if there's conflict between, say, what Chris is mentioning, between
Yeah.
planning and conservation.
Yeah.
DPW has that, is overseas, actually.
Yeah, so when we see built zoning permits and planning board permits, usually we say that you must comply with the stormwater bylaw.
Okay.
So sometimes
So
they,
we have that in ours as
Yeah.
well, our regulations.
Yeah, the only difference I see is that with conservation is the fact that they could have an additional layer of order of conditions because they still have jurisdiction over that property because of its location.
Yeah.
Whereas the building permit, it ends.
right, I'm just talking about zoning and planning and building permits.
Yeah, zoning and planning,
But not
planning
conservation
and
or
building
street.
would end. Conservation's the only one that I'm aware of that continues. With an order of conditions.
So the permit is good for 3 years, the order of conditions.
Yep.
And then they're supposed to request a certificate of compliance to close out the permit.
Yep.
So that is our end. Our end is when they get their certificate of compliance for whatever the project is.
Okay.
It sounds like these are minimum requirements that the building department has to apply. And that
It seems like
boards
this,
like,
yeah.
or boards like the Conservation Commission, but that there should be a language, something that says unless another board has stricter regulations that would supersede these.
I think that, from a discussion with Joe is that, you know, he ultimately issues the permit anyways, and also planning board and zoning have to do is say, you know, meet the stormwater bylaw conditions, and he enforces it, or DPW enforces conditions for the site before someone goes back to planning board with, reduce their bond or get final, you know, we'll submit the final as-bills and, usually, building department and DPW is out there doing the inspections and writing the recommendation anyways. So,
So the bottom line is the stormwater bylaw with any conflictual
Yeah, so I mean, bottom line is, he does most of the enforcement with DPW, yeah. But for stuff outside the
But,
wetlands jurisdiction.
Do we, so the way that the bylaw currently reads is that someone could need to go to ZBA, planning board, conservation, or the building commissioner for a permit under this bylaw.
Yeah.
Do we want to keep it that way if the review is not? From what, the way you just described it, Tom.
Yeah.
The review being applied by the ZBA and planning board would be no greater than simply saying you need to comply with the bylaw.
Right.
Until you get to the building commission. And I think that would not be true of the conservation commission, so I guess. My question was primarily directed at, do we want to send applicants to one of 4 different places under this bylaw? Or do we want to try to? And have the review applied by 4 different boards?
Yeah.
Or do we want to send it directly to the building commissioner with the understanding that DPW and engineering is gonna look at all this stuff?
Yeah.
And that's where the review is happening. And I don't have a preference one way or the other. I just wanna make sure that if we're giving applicants clear instructions about where they need to go. Does that make sense?
Mhm.
Yeah,
Yeah,
I mean, in the case of the bylaw, the way it's written now, the only thing that I would maybe say needs to be added, if at all, if applicable, I don't know how you guys feel about it, would be maybe saying something to the effect of, you know, you need to comply with the stormwater bylaw at a minimum. However, in some cases, such as conservation jurisdiction, they may have stricter rules based on the location of the property. I mean, I don't know how else to say it, not saying, I mean, I'm not saying that they have to do more necessarily, but I'm also not saying that they should be hamstringing conservation from protecting a wetland.
I think that would be appropriate. You might also just want to add that if the review is performed by the planning board first, you wouldn't need, an applicant wouldn't need to then duplicate it if, you know, upon application for a building permit, because the review is already happened.
Yeah.
I just want to make sure we're not doing it multiple times. If that makes sense.
I just, for the town in Natick, they used to issue, a stormwater separate permit. And then what was happening is they were kept on doing duplicate permits. So they had a stormwater permit. And then the building department would do their review, and then they require a permit for stormwater. So it was spinning the applicants in a circle. So my thought is, like, if we simplify it to say that ultimately, building department is going to be issuing the permit for a structure. DPW be issuing something if it has nothing to do with structure, has more site work. And conservation would be issuing a permit if it has to do with wetlands. And then like DPW could be the clearinghouse for reviews. If necessary, and then, you know, like, according to the bylaw right now is that the DPW is an administrative review or something to that effect.
And so that, I guess that, a comment that you just made, Tom, sort of sends me to the next, I think, related question, which is what happens, what do we want to have happen under the bylaw if the applicant doesn't need a permit from anyone else?
Joe has a comment, a question.
I just want to back up a little bit on that subject we've just been talking about, in that you know, uniformity is important. And you know, we have a bylaw and a regulation. And no offense to the Conservation Commission, but I think it should just be one entity that regulates this. You know, just like, you know, we have a building code that everybody has to comply with, but we don't send that to 4 different boards for their approval of how the building code is interpreted. The issue is, you know, that if you have different entities interpreting the bylaw, you're going to get different interpretations over time, as opposed to having one entity that interprets the bylaw and says you either comply or you don't. I think that's a better way to go. So that's my comment on that.
Chris, are you, are you suggesting that DPW might be the stormwater authority?
I think that's one way to go. I'm not promoting that idea exactly, but I'm just, I guess my rooting interest is more just making sure that there's a
Right.
clear path outlined for all the
Right.
applicants and the boards and officials who have to work with the bylaw.
Right,
And I guess, as I reviewed the bylaw, one thing that I am struck by is that it seems to me that this is gonna undercut my prior point, but it does seem to me that on matters of stormwater, at least the planning board and the zoning board of appeals would ordinarily be expected to turn to engineering for the expert review that they need to evaluate the proposal, and then get comments back from Tom and his colleagues, and apply that in the form of an approval, conditions, or whatever in the permit. So, I mean, if there's expertise to be brought to bear here, certainly, I think,
So
with
just
the
for,
permitting boards, and
for
I'll do-
conservation,
conservation, I think it's maybe in a different category.
well, just, we've been lucky enough to have
Yeah.
a stormwater engineer as our
Exactly.
chair for
Yeah,
20 years.
exactly.
And now we have another civil engineer as
yeah.
a chair,
Be
so,
Careful to leave you guys out of.
yeah, but that's just why we don't look to them
right,
for
exactly.
review.
Yeah, we've been lucky that way.
So,
Yeah.
but to suggest that I don't know that it's safe to
Okay.
assume that the planning board can do better than engineering in terms of evaluating the adequacy of the proposed stormwater system.
I'm pretty
Does that make
sure,
sense?
Tom, don't you guys
That's how
do
we
all the
handle-
reviews for the planning board?
Yeah, that's how we handle it right now.
Yeah.
That's how we handle it
So
right
for
now.
planning, zoning and building, engineering does do the review.
Yeah, so, so building under the bylaw, so when Joe issues the building permit. Is everything's assumptions that it meets the bylaw in one way or the other,
Mhm.
so. And if planning board issues the decision and then the building department actually, issues the permit for construction, for the building construction.
Right.
And then again, they're under the assumption that we've done our review. So,
I have a hypothetical. So say there's a building permit, it has to go to the planning board. And the planning board asks the engineering department for its feedback. They say it meets the standards. And, through the deliberations, there's a comment that, oh, there more drainage is necessary on this portion of the parcel. Is there anything that would prevent the planning board from imposing conditions that exceed the minimum standards?
So-
Under zoning. Well, under this bylaw as drafted, I don't believe they would have the authority to do that, because I think, everyone correct me if I'm wrong, but I think this ultimate standard here is like compliance with the stormwater handbook.
Yeah.
And if their engineer has said we meet that standard and engineering agrees, I think the job is effectively achieved under this bylaw. It's possible the zoning bylaw special permit criteria could provide a higher level of review. But I think even there you could. This may be getting into the weeds, but you could. Sort of wrestle with the question, if they've achieved state standards in terms of how they're handling their stormwater. Why would the planning board require them to do more than that? There may be circumstances where that's appropriate, but that's one to think about that.
yeah, typically, the planning board is reviewing like a commercial, which is, this bylaw is taking into account for single family houses. So, the commercial properties and like subdivisions are required to meet the stormwater handbook, which is, there are 10 standards that they must meet, which this bylaw only includes, a couple, infiltration, which they exceed the state's requirement on infiltration, but the design standards are, you have to be 10 feet off the property line, you have to be 10 feet off a structure, you have to, show the 100-year storm events and, you know, you have to do all this math and, we don't require that for single family houses. It's like it's plug and chug, you know, 1 inch, that's it. But then again, there are some things missing in the existing code that we need to address. That's why we're here. But usually planning board is exceeding the bylaw anyways. You know, you need. And usually with conservation commission too, they're supposed to meet the stormwater handbook,
Mhm.
so,
Yeah,
but for single family houses. Typically, they're exempt. Unless there's a wetlands.
right. Yeah.
And the
well,
other thing to keep in mind too is that
Yeah.
with commercial properties, there is also another permit from EPA that is in draft form at the moment and has not been finalized yet, but has gone through its first iteration of called the C2 permit, which applies to commercial, industrial, and institutional properties. So if those properties fall under that, they would be then falling under EPA's jurisdiction. And those requirements are stricter than what we have in here, so they would automatically comply with our bylaw only because they would have to comply with the federal one. I don't know if that helps or hinders our conversation.
So I'll say my opinion, like my preference would be to have. The default be the DPW building department, well, I guess.
Yeah, because we could be, I mean, someone could be extending a roadway or drive. Or driveway or tennis courts, whatever. And if they trigger a street permit requirement. You know, perhaps there's a requirement that they have some sort of drainage control. If they're doing a building, then they're gonna trigger a building permit and then they should, you know. And then it should meet the whatever the bylaw has for the trigger and then. for
I think
conservation.
aside from conservation, engineering is involved in all of the other current permit processes for review anyways, where the stormwater, I wouldn't say assessment, but the stormwater, looking to see if they're doing what they need to do, what is required by our bylaw is included in those permits.
Yeah, okay, so then I would say the default would be for engineering to be the authority unless in some other place in the bylaw, zoning or otherwise, there are stricter standards for a particular body, and those stricter standards, the body that controls those standards would.
Yeah, I'd say it would be based on the property. Like if that property falls under that jurisdiction, then that's who is in charge of what's required for stormwater, for.
I think
Does that make
I
sense?
might have heard 2 different things from Kim and Josh. I'm not, maybe, but
Okay.
maybe, like, so. I think what I heard from Josh's suggestion was that we established DPW as the sort of expert reviewer of this.
Mhm.
But perhaps what we would say is that their review will be performed in coordination with whatever permitting board happens to see a particular project first. And then their review would be applicable throughout the remaining permitting route of that particular project. So in other words, if somebody goes to the planning board, we establish deep engineering as the reviewing authority, but that'll be done in hand with the planning board as part of their permitting process.
Mm.
Does that sound consistent with what you just suggested, Josh? Or
Just one small difference is that if conservation went second.
Yeah.
Conservation has stricter, so I think.
more?
Conservation, I would assume would usually go first,
So maybe we need an order.
because they need to know where they can actually propose to
Yeah,
build.
Yeah,
Okay. I can do that, or I can work with Kim to sort of make a version of that for the bylaw. But I think that dovetails to my next question, which is what happens under this bylaw if no other permit is needed from anyone?
Besides building,
Well, I guess. In the various applicability sections, I thought there was at least one
750 cubic yards of material, yeah,
that would not, so you
Yeah.
could, backing up, you could, I think, remove or add or move around 750 cubic yards of earth on your lot and not need any permit from anyone, depending, assuming you were outside of
Right.
wetlands.
Yeah.
Outside of, if you move that amount of cubic yardage, you likely are using heavy equipment. Therefore, it is required, it's supposed to be required that you get a street permit when you use heavy equipment over our public roadways.
over the curb, yeah.
Yeah,
It'd be a street permit, no.
It'd be a
not
street,
land
yeah.
disturbance.
correct.
It would be a street permit.
To
Yeah.
drive the equipment onto the lot.
Over the,
Yeah.
yeah,
Yep,
Oh.
and that's an engineering review.
yeah, and that's kind of like catch what you can catch, cause like. You know what I mean, just like,
Now, if they go out with a
Somebody
shovel
knows
and
me.
move 750 cubic yards of material, I feel like that's enough effort that hallelujah, have at it, because I wouldn't be doing it myself.
that'd be an education thing, cause like. Sometimes driving through town, there's like, all right, so someone just like drove over one of our sidewalks, you know, and damaged the sidewalk and. Is building, and it's, you know, it's not, there's no permit for a pool or anything like that, they're building a tennis court. You know,
Bless you.
or removing, like a grove of trees or something, you know.
Or if they're regrading their lot or something, like they're using a backhoe or something to get rid of the stuff, so presumably they should be getting a street permit.
So, but philosophically, again, it's, what we're saying is that the bylaw is triggered by the need for that other permit, not by the movement of the 750 cubic.
Yes.
The
right,
street permit, the
Mhm.
street.
Yeah.
How tall would a 750 cubic feet? How tall would that?
750 cubic
Depends how
yards.
wide it is.
cubic
Cubic
yard?
yards. Yeah, right,
Yeah,
yeah,
If you, just as a, just to get it into picture,
yeah.
750 cubic yards.
Oh, I have to do the
Maybe-
math.
We'll have 750.
Janine, can you do the math? She's an engineer.
I'm just, oh, okay.
Mm,
I was
Well,
wondering really how much
You
that,
wanna picture
it
it.
sounds like a lot.
Yeah,
What's 1 cubic yard? And it's 750.
Okay, so it's
yeah.
pretty tall.
Cubic feet, yeah,
Okay. I just curious.
27 by 1 27 feet one.
This reminds me of doing math homework when I was a kid. My dad was an engineer and a surveyor, and I would be in tears.
But I think you're right, Chris. It's the permit that triggers it.
Yeah, you should tell me to look in the back with the answer key.
But the bylaw doesn't say. that.
Yeah, right.
You're trying to visualize this file.
Yeah, exactly how large is, but I do have a quick question. Luckily with Conservation Commission, we would always have a civil engineer at one point, right? If and assuming that civil engineer would be willing to do calculations,
Mhm,
so we've been lucky,
right.
but we might not always have a civil
Right.
engineer. Okay, that's my first, and my second question, Chris, are you recommending that DPW might be the a stormwater authority?
They are already.
I guess I don't have a preference myself.
Okay.
Other than, well, this is not a personal preference or a town council preference, but, you know, the DPW has the expertise in this building to review stormwater design for compliance with the standards, so. You know,
But if we need a
Whether they do
stormwater
it-
authority,
whether they do it for the plan, you know, in coordination with the planning board or independently by themselves, I think that's it could go either way. I do think it's probably impossible for the planning board to review a site plan approval without getting into stormwater. So, I mean, it makes some sense to me that we would wrap these two things together, like a planning board or a ZBA review and DPW's expertise, because it's very hard to was actually at the permit hearing recently. where,
So she's on the Conservation Commission, so she, I think,
It almost sounds like there's gotta be somewhere in the bylaw, there's got to be some kind, I don't know whether you still want to call it a stormwater authority. But I guess what Tom would think too.
Well, I mean, I guess I did have a question, because there is a section in the bylaw that says clearly that the DPW, the director of the DPW is the stormwater, I forget the exact terminology,
yeah.
but is the enforcing authority, or the
Mm-hmm.
in charge of, responsible for administering the bylaw. And I think I understood Kim to say that that's a requirement, that we have that in our local bylaw, but it's not entirely clear to me what that means in practice.
Right.
When you're applying the bylaw, given that the bylaw sort of sweeps in so many other boards and officials in town. It's clear to me that in the illicit discharge and connection of pipes section, that, the DPW can run out and shut off a illicit discharge or a pipe if it needs to.
Yeah.
That's clear. But in the permitting procedural sections, which are, I think, the sections that we're going to be called on to use more frequently, the allocation of I think the bylaw can be a little bit clearer in terms of the allocation of responsibility and jurisdiction between DPW, building, to planning, ZBA, and council. Does that answer your question?
Yes, it does. Yes, it makes it very clear. Yeah.
But it's interesting how a number of communities ended up going to the single authority. And I kind of can understand why, because they probably had a zoning board, a conservation commission, all the same ingredients that every community has. So they were somehow able to build in enough safeguards to the way they did it, so that the conservation faction still felt that they weren't gonna get steamrolled in this. So there's something that the simplicity of having a single authority, but building in enough safeguards, and it sounds like we're partway there. We've done some simplifying and on it, but we still do have a tricky slope to be sure that
Yeah.
the process works. And I mean, we basically, I don't think we've really changed anything from what the current bylaw has from this jurisdiction standpoint. I don't know, Kim, do you? So I mean. it
No,
seemed
we
to-
haven't changed how it works here in Needham at all. The way that we
Yes.
do it now. The only thing that I can see Chris's point of being clearer about is the fact that for the most part, as far as I am aware, and again, I am not an authority on how everything occurs in town here. But as far as I'm aware, zoning, planning, building, all of them have some sort of engineering involvement where they review the plans that are put in front of them for construction, whether it be planning a new subdivision or doing whatever. The only caveat to that is that there could be stricter rules or requirements if a property happens to be within the jurisdiction of conservation, because then they would also be subject to an order of conditions that is not necessarily applicable to every property in Needham. Something that stands next to the town hall in the center of town is probably not going to have the same restrictions as something that's sitting in the middle of a wetland. Does that make sense, what I'm saying?
Yeah.
So the wetland may have more simply because of its proximity to a natural resource. Whereas something that's in the middle of town that's, it doesn't have to meet those same strict guidelines.
No.
But they do have to meet the minimum. So we have this is the minimum of what you have to be able to do. I don't see a case in point where conservation is ever going to say, oh, you're in a wetland. You don't need to infiltrate at least 1.5 inches. You can just infiltrate 0.5 inch. Have at it.
Yeah, no, we have our minimum too. I think
Yeah,
I
but
think
your
we
minimum
really
is always
ended
gonna
up
be
having
more
this
than
in
ours.
In our regulations, because single-family houses are exempt under the Wetlands Protection Act from having to provide stormwater infiltration. So before we had how long have we had the bylaw for?
I think it's going on 6 years.
2018.
Yeah, so
2018.
we've had that as part of our bylaw for longer than that. Because I think we wanted to be able to capture single-family houses, outside of the Wetlands Protection Act.
So it sounds like, I heard Chris say that he was gonna work with Kim to try to work on this language to help, put together what we've been talking about for an hour.
I think I've got,
I mean,
Okay.
have we beat it?
no, I think I've got enough direction to try to come up with, to work with.
Yeah, we
Kim.
just
Sure
need
you
to
don't
be
want
able
us
to
to go
encompass,
over
we
it,
just need
Jen?
to be able to encompass any situation where somebody is doing something in town that could affect either the quantity of water or the quality of water. Now, we're gonna miss some of it because some of it doesn't require any kind of permitting or anything like that. So those are things we can't capture.
Great segue to my next set of comments.
Thanks.
If we, yeah, so I've got a couple more comments and questions. If we could, I think my best comments are, start at section 7.4. So there may be a couple before then, but I think it probably makes sense to start there, because I think it's next to the discussion that we've been having, if that's okay.
Where the fun begins.
Yeah. So in section 7.4, applicability. And this, I think, just gets into I think there's a lot of phrases, and I want to make sure that we're in defined terms, and I want to make sure we're using them all properly and consistently throughout. So I guess question number one is the introductory paragraph of 7.4. It says the stormwater bylaw shall apply to all water generated on any developed or undeveloped lands and to any land disturbing activity within the jurisdiction of the town entering the municipally owned storm drainage system or a water course of the Commonwealth, unless it's exempted. So that's sort of point number one. The bylaw then goes on, though, in 7.4.1 to list 3 sections of things that are subject to the bylaw. And it seems to me that the applicability part in the introductory paragraph is broader than the 3 paragraphs in 7.4.1. And I guess is that intentional? And is what we say in 7.4 overly broad? Because, I guess what we say in 7.4.1 is that we're regulating new construction, work resulting in an increase of 25% or more to impervious surface, disturbance of 700 feet or more cubic yards, construction or alteration of on-site drainage, and new construction exceeding 25% of the building footprint. So is it accurate to say in the preceding introductory paragraph that the bylaw applies to all water generated on any developed or undeveloped land that's going into the storm drain system? Because that is broader than what comes next in 7.4.1. And I guess I wonder if what we want to do is delete or eliminate the introductory paragraph and merely stick with the 7.4.1, which are the specific things that we are regulating in the bylaw.
Yes and no. So the introductory paragraph, again, totally, I'm fine with removing it if you feel it's best, but the point of that one was more to say that any basically the general idea is that any water flowing in, around, through town needs, whether it directly or indirectly ends up in a water course, or directly ends up in, or it additionally directly ends up in our storm drain system, needs to be managed in some way. So whether that be if it's a permitted activity or not, or whatever, because basically I've had a lot of comments or a lot of questioning of, Well, all the water on my property is directed back towards my property, so it doesn't ever make it to the street. Well, that's great, until we get 6 inches of rain in 45 minutes and the whole town is flooded. Then anything on your property is definitely going into the drains and probably bubbling up out of it because our system can't handle it. So we were trying to, or I believe the premise behind it was that not every instance, like, yes, your spouts from your roof are directed to your backyard. Yes, your stuff is in your yard as of right now. And when I get half an inch of rain over the course of 24 hours, likely nothing you have coming off your property is going into our storm drains. However, in the cases where climate change is affecting how frequent and how large the storms we're getting are, water is coming off of your property at some point. It is inevitable that over the course of 5, 10, 15 years, we're going to have more and more storms, and they're going to be of greater intensity. And those things are going to leave your property in some form or fashion. I'm thinking perhaps to clarify it a little bit, it should say, maybe applicability should say activities subject to permitting would be the better way to state that. Although I don't want to say that we have a land disturbance permit, because we don't. That would be a street permit. Does that make sense, what I'm saying?
It makes, it explains the need for the introductory paragraph. I guess I worry that the bylaw, if the bylaw aspires to capture or regulate water movement that is subject to the introductory paragraph, but is not captured in section 741.
Yeah.
I worry that the bylaw does not clearly regulate the difference between the two. Does that make sense? In other words, it's clear enough to me that anything you're doing in section 7.4.1 will trigger the need for a permit. It's not necessarily clear to me what if you are just discharging water, from your gutter out onto the street and into the storm drain in a heavy storm, what this bylaw is asking of you.
I think it was more of the reasons to explain the reasons why you need to capture the amount that you do and why we might require more if regulations from EPA change for other reasons. And that potentially is not stated in the right way in that paragraph. Does that make sense?
I guess.
Basically, I'm just trying to say to every entity or resident that the water within town, whether it comes from the sky or from your washing machine, we would have authority to state that something needs to be done with it. It doesn't necessarily mean that everything you personally are doing is causing it at the time. It just means that for purposes of like our, say for instance, our stormwater assessment, it's based on your impervious cover, even though everything is directed into your land, your impervious cover is still affecting how that water runs off your property if you didn't have anything there. If it was just an open field, we wouldn't be having the issues that we're having, or not wouldn't be, but we'd be less likely to have as many issues.
So was this taken from a section of it taken from another bylaw, Kim?
Yes, I believe this was taken from Natick. If not Natick, it was the
model bylaw.
the model bylaw, yeah.
Okay.
Kim, can I restate what I understood you to say? But basically, the introductory paragraph is saying for the purposes of measuring stormwater. All of these sources, any water generated from any of these sources is to be measured, is to be counted in that measurement.
I wouldn't say it has to do with measurement. It has to do with us effectively regulating or applying our stormwater our stormwater process to any condition. As of right now, the activities that would trigger and be subject to the bylaw are these three categories. Whereas if there's another category that comes along that is identified by us or EPA or someone else, any water that potentially is flowing around in town is potentially subject to, I want to say regulation, but I don't want to keep using the same words because I think it's confusing, but it's subject to our rules.
But I guess this is just, maybe this is my confusion, and I like this discussion because I didn't realize this before. We're not regulating water, we're regulating the activities that change the course of the water or displace the water, right?
Yes, so basically what I'm saying is that because these three activities generally affect that opening paragraph, like anything that's happening or goes into the water, either goes into our storm drainage or ends up in the Charles River, these are the activities we've identified in Needham that do that.
So
And like I said, maybe it's just not phrased correctly.
I don't think we can say we require a permit for the three items in section 7.4.1 and anything else relating to water moving off your property.
Okay,
We can specify more things in 7.4.1.
Yeah.
But I worry about providing three examples of what we're regulating by permit. And then also saying, but that's not a complete list. You may need a permit for other things too. Does that make
Okay.
sense?
Yeah, I see your point. I mean, it is confusing. It
Or-
opens up a whole nother set of unknowns.
Or we could take it in the opposite direction and say, we require a permit for all water that leaves your property.
No.
But I think I want to think about that, and I don't know that we want to do that. But it seems to me that that's almost what the introductory paragraph does.
okay. So should we remove the first paragraph? All in
I would
favor?
move for
Don't
that.
talk, don't all speak up at the same time.
Well,
I would vote
I
for
guess
that.
I think so, but the caveat I would add is that if there is a particular type of thing that we think we're giving up by deleting that introductory paragraph that we want to regulate, we should just add it as another thing that requires a permit under 7.4.1.
Yeah, no, I don't wanna open us up to saying we regulate anything that comes off your property, because as soon as we say off your property, then they're like, well, none of it leaves my property.
Yeah.
And I want to avoid that at all costs.
Yeah, the other thing that happens is people will say, you know, there's water coming off my neighbor's property coming onto my property, so therefore you gotta do something under this bylaw.
Right.
I mean, we've always got the ability, if EPA changes the rules and requires something more, I mean, we've said up front that we need to be in compliance with, state and federal rules. So
Right.
that's kind of, because I hear, Kim, what you're saying is that there's a future out there that's gonna probably be more restrictive as time goes on. And I guess we just have to deal with it, if and when that happens, and we can't sort of write in something that's so general that we'd be able to point to it and say,
I I agree too with the. If we go
So
right
I'm good
into
to strike this out?
the activities,
I think so.
Yeah.
I mean, we didn't have it before. I think, but it was a good idea that we saw it in another ordinance and it seemed to just give us a little bit more clout, but I can see the confusion. Which do you go with? Do you go with the three specific items or do you go with the general catch-all?
And
Okay, so,
would there be anything else to add under that, under 7.4.1?
Tom, are you good with deleting it?
yeah, I think it should go right into, basically you want someone to read through this and go. Okay, who's applicable? What am I doing that is gonna trigger? And then, if you have this first paragraph in there, I think it, leads them to think. If it rains, then I owe somebody something,
Yeah.
So,
Okay.
okay,
and it
so we
doesn't-
remove the first paragraph, which means that this comment here is resolved, correct?
Yes, I think so.
Okay.
That is all.
Yeah, and I think the definition of stormwater captures everything that was in there anyway.
Okay, moving right along.
So if we could now, that we sort of revisit, I think, a similar question in 7.4.2. Because the first, in 7.4.2, the first phrase we're using in 7.4.2 is land disturbing activities.
Yeah,
And they shall not be segmented or phased in a manner to avoid compliance with this bylaw. I don't know if land disturbance activities is the right phrase here, or if we just want to say, the three, the activities specified in 7.4.1 shall not be segmented or phased in a manner to avoid compliance, because again, I think land disturbing activities is defined in a way that is broader than the three categories in 7.4.1.
okay,
yeah, can I back up a little bit too, is,
Yeah.
So activities subject to the bylaw 7.4.1, and then 7.4.2 is stormwater management and erosion control. So I mean, I take this, the hierarchy is like, okay, you're subject to the bylaw if this, and then therefore you have to do stormwater management control. Is that how I'm reading it?
so basically, land disturbing activities shall not be segmented. Basically, what we were trying to avoid is people saying, well, I'm only building 500 square feet here, or I'm only disturbing 700 cubic yards. I'll do the other 100 next year and permit the 100. So therefore, they wouldn't fall under the bylaw.
Right,
Okay.
so my question, but my point is that land disturbing activity is any activity, including without limitation, clearing, grubbing, grading, digging, cutting, removal of vegetation or trees, excavation, placement of fill, resurfacing and construction that causes a change in the position or location of soil, or a change in the patterns of drainage and or infiltration of water.
Right.
So you could, I think, so what 7.4.2 currently says is, among other things, that you can't segment grubbing to avoid compliance with bylaw, or digging or cutting or removal. But the way the bylaw is set up, I think you could grade, remove vegetation. I think to your heart's content, without violating this anti-phasing section, because in this section, we're saying, well, backing up, if we make the change that I suggested, we're saying that 7.4.1 lists three categories of activity that you need a permit for.
Yeah.
But if 7.4.2 is applicable to land disturbing activities, we're sweeping in a whole broader range of activity that I don't think we mean to cover here, but everyone should correct me if I'm wrong about that.
I mean, shouldn't we just say the activities subject to this bylaw is listed in 7.4.1
That is what I
shall
would-
not be segmented?
That's what I would do.
Then the thing flows,
Good.
And we eliminate the addition of a new defined term that, you know, will, I think, lend us a little bit of confusion.
Well, we do, I think, still need that term because it's referenced in 7.41. So the second one, all persons or entities proposing a land disturbance activity involving the addition of 700 or removal of 750 cubic yards of soil. So grubbing is fine in, as long as it involves less than
Yeah, we've got
removal
it,
or addition of
right, we've got it
750.
covered, yeah. Kim, are you good with that?
I changed it to say activities listed in section 7.4.1 shall not be segmented or phased in a manner to avoid compliance with this bylaw.
As far as the activity subject to the bylaw, I mean. I want to say that I'm not sure if we. Made all the activities that we were, originally set out to do. I mean, should we be adding in? Like grading within, like 10 feet of the property line that increases the grade and directs water towards the neighboring or off the property, construction, dewatering activities,
Yeah, that's where it would go in 7.41, right?
yeah, and continuing the use of, well, the requirement. Constructing with, in the water table such that, a sump pump activity needs to be discharged. So we're not allowing them to discharge within 10 feet of the property line. That they. Those type of activities should be subject to review.
What
Like
about
if they-
cases where somebody puts in a wall, like if you build a
Retaining
a
wall,
wall, a retaining wall or something on your property and and make it like the length of with your neighbors, like a stone wall or something like that. And you only
that's,
put in. It's not, I don't know
That's
that goes to, that doesn't trigger a building permit. I mean, assuming it would trigger a street permit if you had enough of it, but if it's just somebody bringing over a bunch of large boulders every time they go walking in the woods, I don't know.
but what's your thought on? So somebody. Is building a wall on their property, which otherwise would not require a building permit, a street permit. But then they start. Getting complaints of the neighbors, like the redirected flow, then that's something that we can. Administratively review, say, you need to do some. It doesn't trigger a permit, but it does trigger a review suddenly. I was like, now you're creating a flood issue for your neighbors, so therefore, unfortunately, they're not gonna find out maybe for like a year or two later, so,
If it
I think
doesn't
that's,
trigger a
that's
permit,
important, I mean, it's
Right.
important,
but if it doesn't trigger a permit, there's no authority.
no administrative review though.
yeah.
Yeah, but
I
even if
know,
you
like,
administratively
I wanna see
review
what
it, I mean, he's gonna
happens-
review
what
it and
happens with the-
say,
What's
if
happening?
he's gonna
with
review it and say you're gonna, the wall is causing the flooding. If there's no permit or no anything else, there's nothing we have that says you have to remove it or do something about it.
So, to your point, Josh, the bylaw as currently drafted doesn't capture anything that doesn't, well, mostly doesn't capture anything that doesn't require a permit.
It doesn't require what?
Another independent permit. It could, but that's not the way this bylaw works. In other words, you could make, I think, a much lower threshold for with the retaining wall scenario, or a much smaller disturbance threshold than 750 cubic yards that would trigger a separate new permit administered under this bylaw by the DPW, but this doesn't do.
No, I think
Is that-
the goal is not to have a separate. That's what we discussed.
Right.
But somehow I think that should be addressed, I think that's really important, somehow should be addressed through administrative review or something. I did have a mud flooded basement, my house next door.
I think that's what we were trying to get at with here. Saying involving the addition, on-site redistribution of, or export of more than 750 cubic yards of soil is subject to the bylaw, but how they're subject to it, we don't really have.
Yeah, so like the comment I have up there, raising the property grades, adding, pipe discharges within 10 feet of the property line. I was saying that the city of Newton was experienced because they had their bylaw that you need to be 2 feet above the water table to build a basement. So everyone started building the basement up higher. Then they had the 3-foot reveal requirement maximum for the foundation. So they raised up the property. So they built walls all the way around. So now, from stormwater aspect, you say, okay, the property is not discharging more water off their property. But they're not calculating the water coming onto the property that otherwise come onto the property and is now diverted to the neighbors.
Right.
So that became, so now they're trying to resolve that issue because people are building walls around their property now.
Right, so this was, I think that was supposed to be our attempt to incorporate quantity. Because the first and the third paragraph really have to deal with quality more than anything. So the middle one was more about quantity of water.
And the land disturbance activity, it's somewhere in there, I think a street permit should be connected with it, because I don't think
Yeah.
many people know about a street permit.
Yeah.
I didn't. But the street permit is not mentioned anywhere in connection to the land disturbance activity.
Right, it's not, I don't think it's mentioned at all,
Yeah, I
Yeah.
don't see it in it, yeah.
so. I mean, that could be a trigger for how we can review projects that otherwise don't trigger conservation or building department, so the street permit process.
Um,
I'm just looking at the time. Can we try to get through some more of the comments?
Okay,
Next one, minor. In the second sentence of 7.4.2, we say, except as listed below, all applications for new construction or redevelopment subject to the provisions of this bylaw. New construction or redevelopment is again another sort of introducing another term that I don't know that we need here. Is it valuable to say new construction or redevelopment here, or can we just again say, except as listed below, all applications for activities listed in 7.4.1 cross out subject to the provisions of this bylaw, whether or not the issuance of a building permit is required shall include stormwater management, erosion control. I just don't know if new construction or redevelopment lines up exactly with what we've said we're regulating in 7.4.
What section? are you in? I'm sorry.
7.4.2.
I think that was more to deal with, if regardless if you needed a building permit or not. In other words, if you put in
Yeah.
a 200 square foot shed and it doesn't trigger needing a building permit.
I
or-
guess my
so-
only thought was movement of 750 cubic yards of earth by itself would trigger jurisdiction of the bylaw under 7.4.1, but might
Yeah.
not qualify as new construction or redevelopment.
Okay,
Does that make sense? So I think we again just want to, in the second sentence, again, just refer to section 7.4.1.
okay,
Good.
so how do you want me to change the paragraph to read? So activities listed in 7.4.1 shall not be segmented or phased in a manner to avoid compliance with this bylaw.
And then except as listed below,
Yeah,
activities listed in 7.4.1. Whether or not the issuance of the building permit is required, shall include the stormwater management and erosion control provisions.
activities. Listed.
Next one.
Uh,
Whoops, sorry.
Yeah, just a question on 743 modification of stormwater plan. Prior to any change or modification of an activity associated with the stormwater management and erosion control provisions of the permit. Shall obtain the approval of the permitting authority. So I guess. How do we want the modification section to work? If. They've got a special permit from the planning board or ZBA, I can see coming back for a modification. If they've just applied for a building permit for a single family house. And they want to make a change to the stormwater permit, do they have to go back to Joe? For a modification of the building permit? If they're not making any changes to the actual single family structure itself, I guess. I guess, backing up, I read 743 as requiring. Everyone to come back for any change to the stormwater system. To whoever they got a permit from in the first place. Is that what we want to do? That's not a leading question. I just want to confirm what we want to require of an applicant.
So if planning, zoning, or conservation says you need to change your stormwater management and or erosion control plan before the building inspector goes out to look at it, I'd say, yes, we want them to go back and tell that permitting authority that it's further things have been required or something has been changed or modified in the plans that I originally provided you. Because correct me if I'm wrong, Joe, but if he goes out, he's basing it on whatever original plans were given to him at the time of the permit issue, at the time of the permit application. He's not necessarily looking at anything that's been modified by another board.
Okay.
So do we require, soil test pit data before? Because I think
We do not.
most of our amendments are because they don't do the soil testing first, right? Then they find the groundwater's too high, so they can't put a system in. So then they're coming back and trying to do a rain garden or something else.
Right.
So in our regulations, we require the soil testing to be done before we'll issue the permit now.
We do
Right.
not require soil testing.
Well,
We need to, and I'm not
Maybe
sure
we
whether
should.
it should be in the bylaw or in the regulation or.
cause I think that would like cut
And-
down. For single family houses, the requirement for modifying it.
It's like the issuing authority needs to be convinced that, that they have a design that's gonna work.
Right, and you're not gonna know that unless they do soil tests.
Right. I mean, if you leave it that vague, then we can add soil testing to the regulation and then,
Did we
Mhm.
address any soil testing in the poor soils section? Or
No.
inadequate
No.
soils or whatever we called it?
no, that whole area, that whole section, I think we need to. Correct, fix,
All right.
update,
Which section?
the one about poor soils and, yeah. I think.
So,
They just misunderstood. No, wait a second.
Yeah, no.
I
They
misunderstood.
do have,
So this
They keep saying
comment
that,
from
keep
legal is all set then?
Being there on midnight.
Mm,
Chris, is this comment all set then?
I think that comment is all set. I think with the understanding that we're gonna add something about street permits, because that, I think, is the other permit that will capture the activity, the regulated activities that are not, that might not need a permit from planning board, ZBA, or council. Or Joe.
yeah,
And so with the understanding that everything we're regulating the bylaw should require a permit from planning board, ZBA, Conscom, Joe, or a street permit from DPW. Does that sound right?
yes.
Yeah.
I mean,
Great.
I have a question. A while ago, we spent a lot of time talking about possibly having a single authority. But yet it appears we're not making any change to that language. So in both 7.4.2 and 7.4.3, it clearly says, you know, planning board, conservation commission, zoning board shall review and issue stormwater. Are we keeping that the same?
Yeah, I think we're having, whoever would issue a permit is in charge of integrating stormwater regulations into that permit.
Okay,
He's responsible for. And I don't mean to presume, but I think what I add is responsible for reviewing compliance. Reviewing for compliance with this stormwater bylaw with the assistance of DPW and engineering. And including some discussion or note or comment or condition to that effect in whatever permit it actually issues.
Yeah, thank you.
okay.
So we need to strengthen, you just said.
Shall review and approve in,
I think we recited back.
yeah. So the relevant
Well, I think
permitting
it's just-
authority shall review and approve or shall
Shall
review and,
shall conduct a review for compliance with this bylaw. With the guidance of the town engineering department. Or should I say DPW?
Say DPW, yeah.
With the guidance of the DPW. And shall note its conclusion that the terms of this bylaw have been satisfied in the permit that it issues.
Yeah, that way is one-stop shopping, they don't have to keep spinning around, right? Then we don't have to issue a separate permit. Soon as Joe issues his permit, that's your stormwater permit too.
But Joe's gonna go last almost all the time.
Right.
so it's
Or-
now
or-
going to read, the relevant permitting authority shall conduct a review for compliance with this bylaw with the guidance of the DPW.
And shall note in any permit. Its conclusion. That the project. That the
Well, that's
project
what I wondered.
satisfies this bylaw.
Yes, what about our authority? What's happening with us? Oh, so you've joined our group mentality. Yeah, Sue and I are kind of set operators.
No, we're good.
If you had it, yeah.
If we had authority,
No, you said you're losing it.
oh, yeah.
Is this
Did you have
increasing,
no?
is this increasing any workforce for DPW so far?
And that would be a period there.
Only if you guys send us over stuff.
And put an asterisk
'Cause-
except for
Cause other than that,
conservation.
cause for planning, zoning,
It's pretty
and
much,
building, we usually do the review, but
so we could cause a problem.
yeah, so, but
Yeah, to Deb's point, I mean, should we say minimally satisfies this bylaw in the permitted issues? Subject to any additional standards that may apply.
No, so I would say, no, yeah. So I would
No.
delete, if you don't mind, Kim, I would, for the sake of argument, delete that. And then at the end, after issues,
Yeah,
semicolon.
Yep.
Provided, however,
You.
that nothing shall
It's not a.
the nothing shall, affect the jurisdiction of any permitting board under a bylaw, rule, or regulation with more stringent standards.
Maybe you guys should all just come over to the conservation side. And just
We're-
go with our
we're all
more stringent
eventually gonna work for
standards,
you
and
guys.
then we don't have to worry about it.
Do you want to be the permitting authority, Deb, and take over
More than
Nippies?
anything, Kim, I'm glad you finally asked me.
You wanna take over Nippies?
More than anything, thank you,
Yeah, I'll hand you the reporting for Nippies
Okay.
too.
much appreciated. Mm.
All right, should
Thank you.
I plow ahead?
Does that allow the permitting board to apply less stringent standards?
No, I think it's bylaw or something greater, depending on their bylaw regulation.
I think that just says that the review under this bylaw will be for compliance effectively with the stormwater handbook. And if the conscom has, what I meant to say there is that if the conscom has more different or better regulations applicable to stormwater, they,
So, but we
No,
would
no,
still be considered
I
the issuing
want-
authority?
you're you could be the relevant permitting authority. In the beginning of that paragraph, and if you are the relevant permitting authority, you're gonna review any.
And we're the relevant permitting authority when it's in our jurisdiction.
Yes,
Hold on.
if they come
let
to
me-
you, right, if they come to you for an application and somebody else first. But if they do either of those things, then you still get to apply the wetlands bylaw and
Does this say what you think it's saying?
I like that, Kim.
Are we good with that?
Deb, does that satisfy your conservation
That's fair, that's good.
mind?
Oh, you woke up,
I just want
sorry.
to be clear, the stormwater handbook, those requirements are much stricter than the bylaw. And for a reason too, this usually it's dealing with larger projects, dealing with commercial, not single family house lots, which I don't think are gonna. Most of them are not gonna be able to meet the stormwater handbook. Just for design purposes.
are there examples where we would want to use this bylaw to force compliance with the remainder of the stormwater handbook?
I think just for the infiltration purposes alone, is probably significant. Because the handbook only requires a half an inch, and we're gonna require an inch and a half. But, or I think we come to that conclusion yet, I think we should have this consensus.
That's what we, yeah, that's what we voted
but-
on.
The handbook requires that you do all the documentation, the 1000 unit stone event. I'm not sure if we have the appetite to ask people to hire an engineer to put together this document. Summarizing, that. That they meet the 210 and 100-year storm events. Maybe we do in some cases. For the larger projects.
So it seems like they should have to do soil testing. I
Yeah.
mean, if you're making them come up with a document this big based on all of these theoreticals. Shouldn't they have soil testing
Yes,
as part of that?
yeah, absolutely,
So are we
absolutely.
10.
$710.
I agree with that.
But.
What section are we
I'm
talking
saying,
about?
while they're
'Cause I'm
doing the
not
soil
seeing it.
testing, I'm saying like, don't give us all the paperwork, like we're, for these small projects, we don't need
Mm,
2 we don't need
Right.
100 pages of documents for
Yeah.
a small house lot.
right,
But maybe for a larger, yes, we do.
right.
For a conservation thing, yes, you do.
Do we ever outsource our review? Like, does Beta ever, like,
No,
town projects or anyone else review our stormwater?
for a project that we do. Oftentimes we're working with the consultant.
So someone else reviews for us?
Often often we have a consultant that we're hiring to do a project and we review their work
Hmm.
as we're getting ready to put it out to bid.
Okay,
And I think it's very rarely that we put something out to bid that the consultant reviews unless it's like a traffic study or something.
okay.
Yeah.
So stormwater is all in-house.
Stormwater is elements.
Yeah, I think soil testing could be added to 7.10. Somewhere in there. I'm getting kind of tired.
Yeah, let's,
No, the
It's
new
not like
baby.
you have a
know?
baby at
Yeah, I
home.
know.
It's past Josh's bedtime. We gotta wrap it up, guys. Chris,
okay,
are you
we
coming to
almost-
all our future meetings?
know.
Yes, I am.
You're gonna be our regular guest.
So.
All right, I mean, I added a few notes and, but I'm thinking like, I'm really adamant that we're seeing a lot of projects that have grading that's going right up to the property line. In fact, sometimes the contours, they're showing like 2-foot contours and like the grading could be actually on someone else's property, this is, we're looking at a 2-dimensional. And people are concerned.
Yeah.
So there needs to be, I think there needs to be a trigger. If if they have a project going on, I'm not sure how to get the trigger to get it to the review process, like if they're doing under 25% of a building envelope but they're grading I guess 750 cubic yards, I guess that's the trigger.
I think it's huge if we're doing capacity, and I
Yeah.
think that it's gotta be in there.
Yeah. And
Okay.
then some pumps discharging onto neighboring properties or
Yeah.
roof leaders. I don't wanna be chasing after all the existing houses in town that have, oh, my neighbor's got their roof leaders. That's been there going 20,
Yeah.
for the last 20 years, like,
Yeah.
I don't wanna be chasing that
Yeah,
down, but
yeah.
if they're building a new house.
Right.
That's when you fix it. So,
So I know we're anxious to get out of the building, and go home. However, can we discuss next meeting's schedule here really quick? Because I don't have anything booked. And I want confirmation that we are canceling the room reservation for the June 17th public presentation, correct?
Yeah.
Yes, I think we
Yeah.
booted those 2 dates, but could they potentially become regular stormwater team meeting?
Yeah.
When
Board
does the
of Selectmen.
select board meet?
The 10th and the 24th.
Yeah,
The 6/17,
Yep, I can do the 17th.
What date? Oh, sorry.
we could do a meeting
Tuesday.
6/17. That's a Tuesday, right?
6/17,
Is there another one you want to add
Yeah.
earlier? than
Yeah.
that?
yeah, I'm thinking we need to. But, yeah,
Let's do it before that.
The 3rd,
That's
Cool.
next week.
June 3rd.
Oh, it is.
Yeah, next week, June 3rd.
June 3rd, yeah, right.
I can't do June 3rd, but you guys
I
are
can't
welcome to
either.
if you want to.
yeah. How about the 4th?
And Chris's schedule.
I
right?
can't do June 3rd, 4th, or 5th.
Okay,
Oh, my.
Maybe we're meeting
I'm
on
in
17th.
training for VPC. Yoo-hoo!
Oh, fun.
oh, yeah.
For what?
VPC. This is a permitting software that we, have.
Oh,
So we can't
Okay.
do next week then unless
So,
it's Monday?
Well,
What about the 11th Wednesday? Gonna be a Wednesday?
I think there would be.
Is it the
Wednesday.
4th? No, you can't, right?
I'm no good on.
I mean, you guys can still meet. I just won't be here.
No,
won't
you have
either.
to be there.
We almost need you more than Tom. No, oh, I'm sorry.
No.
I'm kidding, I'm kidding.
Can I propose we meet
I'm
next?
glad you didn't say Justin.
What?
I guess I propose we meet next on the 17th, but then maybe if there's like a little subcommittee. Like Chris and Kim and like, I'm happy to volunteer to like work out these comments, or if you want, like anyone else. Not anyone, but it's some
Can
small
we do
group.
subcommittees on the working
Small
group
group.
committee without people voting on
Small group.
things?
Well, we don't have to vote, but you can agree to the language to get through, kind of like what Tom.
Yeah.
Did. You guys made some progress. I think it's a good idea.
Maybe I'm saying we need another meeting before the 17th for whoever is available.
But are we so the 17th is
Yeah.
happening? Yeah,
Right,
So June 17th, okay,
that'll be a regular,
regular
meeting.
stormwater bylaw meeting, yeah,
Can you come then?
yes.
yes,
I know, we have to
Okay.
ask.
and then Tom
Chris is scheduled.
and Chris can meet sometime before that. We'll keep plodding away on this document. And Kim, sounds like they need to coordinate with Kim.
So-
Three of you,
I mean, it's been helpful. I mean, I can work with Tom anytime, any day, and Kim as well. I guess it's helpful. It was helpful for me, at least tonight, to sort of have the actual committee members here to sort of, thumbs up, thumbs down, yes, no. I don't wanna assume, so I can, it seems to me that without the committee present or a subcommittee of the committee present, it's harder for us to make decisions about the content of the bylaw. So either we
Yeah,
can,
that's understandable.
make suggested changes, but I don't know that that's valuable without everybody here to give feedback. So
Hmm.
can proceed in any way that the committee wants, but I just don't know how much
Hmm.
it's helpful to work with Tom offline during the day, but I just don't know that between the two of us, we're gonna promote any changes of our own.
I mean, we could add the suggested changes and then say this is why we're thinking, kind of in the margins, stick with like, this is why we're thinking such a way.
I'm just afraid I mean, we gotta do something, cause
Yeah.
we have, the schedule is just crunch time.
Yeah,
Here
if
to
the
move
only,
forward.
if we don't do anything before the 17th, we're just gonna
We're,
miss.
we're-
lots of things.
so,
I can do the 2nd, I can do the 6th. I can do,
What day of the week
Weekends?
is-
I can do the 9th, I can do the 11th, 12th, 13th. 16th, 18th, 19th, 20th,
What's the second?
That's Monday.
Oh,
the
that's
second,
right,
June
that's-
2nd's a Monday.
Yeah, I can do June 2nd too.
I can do June 2nd.
I can as well.
Oh, you can?
Monday,
Monday,
should
June
just-
2nd, sold. Whoever can attend, can attend.
Joe, that's a problem for you?
Is this a regular, yeah, Mondays are not good for me,
Yeah,
but is this a regular meeting or,
Yeah, the
this is where
2nd would be a
we'd like
regular.
it to be if we could, but
yeah, I,
The
and
6th is a
this
Friday,
Monday,
right?
but, I mean, that is kind of short, sometimes I can squeeze in a Monday, but this is too short a notice.
yeah,
Okay.
that,
Today's the 28th, we're talking next Monday.
Kim, what was your next date after the,
She said the 6th.
It's a Friday. No.
Friday, the 6th. Nobody wants to do Friday because it's a half day.
I'll do
But,
it, I'll do
um,
it.
I can't do that,
I can do it earlier in the day. It doesn't have to be 7 PM.
well,
Yeah, let's not do Friday.
I got a date with Gabby tonight,
You
Well, look-
do.
she's
Joe,
doing a presentation out.
oh, nice, yeah.
Oh,
Well,
she
guess
is?
what? The climate.
John,
action-
are you cheating on me?
So, could you do
Um,
Monday then?
Monday the 9th?
Yeah,
That works.
Yeah, I probably could.
Yes.
So not the 2nd, but the
Yes.
9th.
Okay.
Chris come in too?
Good.
So far we have June 9th and June 17th.
Good.
So we're not doing the second anymore?
We're not doing the
Why did
second
I write
anymore.
it in pen?
You do that with crosswords too, don't you?
Oh,
So
and you
9th,
guys-
17th, anybody for the third week in June? 23rd, 24th, 25th, 26th, 27th. I know there's a select board meeting on the 24th.
We're doing the 9th, is that right?
We're
we
doing
just
the
start with
9th,
those
Monday,
and see how far we get.
17th Tuesday.
Yeah.
9th and 17th, okay. I
Yeah.
will put those in and I will cancel the public meeting at town hall. And that
Do you
will
want
be
to
to
try to get
determine.
one more meeting in June?
That's what I was trying.
Let's
But
just. wrap this
everybody
up
said
now.
just start with the 2.
What about a Wednesday?
Wednesdays are the 11th, 18th and 25th.
25th?
Yep,
Is that any good for anyone?
25th? All right.
yep.
25th.
That would spread it out a little bit.
I'm gonna presume we're not meeting the first week in July, because that would be the 4th of July week.
That'll be a year. It'll be a year.
Only if we bring.
We've
fireworks.
known each other for a year.
Well, I
And
noticed,
then Chris, you're gonna get with Tom to go over stuff offline with suggestions, maybe?
We should, yeah.
Yep,
Okay. If there's any days in the middle of the day that work
Keep it-
well, I'd love to be in on that conversation, if you don't mind my button in.
That sounds great.
Yeah, I'll try to reserve the Webster room again. Actually, there's, that computer was not working, for some
Once you
reason.
have IT, check it out.
Is Alex
Yeah.
broken?
It was definitely Alex.
I'll be sure to bring.
See,
that up
if I
in the
brought,
next
if I came in tonight, I was gonna have to have my
Tom's mad
husband
at
drive
you.
me, or you could have had IT come and service the
Tom
computer.
doesn't get mad at anybody. He's got mad at
But
you.
he's pissed.
So 9, 17, 25.
yep.
He closed.
Yeah.
That's what I have, yes.
Okay.
He's
I think-
signaled that he is done.
I think we need a motion. Unless we have
Who
anything
would like
else.
to motion to adjourn?
Motion to adjourn.
Motion to adjourn by Joe has been made, seconded by Kevin, okay, and
can't
roll
vote.
call vote is Sue,
Aye.
Deb,
Yes.
John,
Yes.
Josh,
Yes.
Tom,
Yes.
Joe,
Yes.
Kevin,
Yes.
Trip,
Yes.
Janine.
Yes.
Poor Trip is saying, yes, by God, yes, let me go home.
His home.
All
Isn't
right,
it?
let me go to bed, is what he's saying.
Oh,
Thank you very much, Janine, Trip, Kevin, Joe, for attending online. I appreciate you guys so much. Thank you.
Thank you. Good night.
Have a good night, everyone. Thank you.
Yeah.
24.
Thank you.
Okay, I am
really
stopping the
are.
recording now. Thank you,
You're gonna
everyone.
wait and listen to all of us here.